The three men wearing black, sleeveless tactical jackets were in the middle of explaining to a visibly confused county sheriff why my privately owned valley supposedly needed to be seized immediately for unpaid HOA assessments. When I arrived on the scene with my attorney and the original land grant documents dating back to 1887, the lead enforcer was halfway through a speech about emergency liens and foreclosure authority. Sheriff Martinez looked up from the paperwork I handed him, then looked back at the three men, and suddenly started laughing so hard he had to lean against the hood of his patrol car just to stay upright. That was the exact moment these scammers realized they had made a catastrophic error. My name is Zach. I am a 38-year-old real estate attorney specializing in property rights and land use law. I graduated from the University of Texas School of Law and spent 12 years working for a firm in Austin handling complex property disputes, easement litigation, and land development conflicts. I know property law thoroughly, which made inheriting my grandfather's 1,500-acre valley in the Texas Hill Country outside San Antonio both an incredible blessing and an enormous responsibility. My grandfather, William Thornton, purchased the land in 1952 from a family whose ancestors had received it through a Spanish land grant in the late 1800s. The property included dense forests, open meadows, a spring-fed creek, and sat nestled in a valley surrounded by rolling hills. It was breathtaking and unquestionably mine, with a clear chain of title stretching back nearly 2 centuries. What I did not realize until that morning was that the Ridge View Heights subdivision had been constructed on the eastern ridge overlooking my valley, and their developer had apparently overlooked one extremely important detail. The access road serving their entire neighborhood crossed my land under a right-of-way agreement that expired when my grandfather passed away. The lead man in the tactical vest, whose name tag read Enforcement Director Palmer, raised his tablet as if it were sacred text. Mr. Thornton, according to our records, this valley property has accumulated $47,000 in unpaid HOA assessments, maintenance fees, and violation penalties over the past 6 years. We are authorized to initiate immediate foreclosure proceedings if payment is not received within 24 hours. I leaned casually against my truck and crossed my arms. What HOA? The second man, shorter, with a shaved head and a name tag that read Officer Brennan, stepped forward holding a clipboard. The Ridge View Heights Homeowners Association. This entire valley falls under our jurisdiction as HOA common area properties subject to assessments and maintenance obligations. Sheriff Martinez continued reading through the documents I had provided. He was a third-generation law enforcement officer who had known my grandfather personally and understood land rights better than most attorneys I'd worked with. His expression shifted from mild confusion to outright disbelief as he compared the survey maps to the fake HOA paperwork Palmer kept shoving toward him. Gentlemen, I said calmly, this valley is private property. It has been privately owned since 1887. There is no HOA covenant condition or restriction attached to this land because it predates your subdivision by roughly 60 years. My grandfather purchased it in 1952. I inherited it 8 months ago. The title is clear and completely unencumbered. The third man, taller with gray hair and a name tag reading Officer Kendrick, lifted his radio. We have documentation proving this land was designated as HOA common property during the Ridge View Heights development in 2018. You can dispute it in court, but until then, you are trespassing on HOA-controlled land. That was when I smiled. Sheriff Martinez noticed immediately and grinned right back. He already knew where this was going. That's interesting, I said, pulling a thick folder from my truck, because I have the original survey from the Ridge View Heights development right here. Your subdivision was built on the ridge above this valley. The developer, Crestwood Properties, needed access to the county road, but the only feasible route crossed the northeast corner of my grandfather's land. So Crestwood negotiated a right-of-way easement with him in 2017 to allow road access for construction and future residents. Palmer waved his hand dismissively. Exactly. Which means the HOA has legal access rights to this property. The easement was for road access only, I continued. 20 feet wide, precisely defined in the recorded documents. It did not convey ownership, did not convert private land into HOA common property, and did not grant any authority over the valley itself. More importantly, The easement was granted to my grandfather personally and included a termination clause upon his death unless renegotiated with his heir. I paused. That would be me, and it expired 8 months ago. All three men stared at me. Brennan was the first to recover. That's not how easements work. Once granted, they run with the land. Normally, yes, I replied, but my grandfather was a very careful negotiator. He knew this land would increase in value, and he refused to permanently bind his heirs to an access agreement. He structured the easement as a personal agreement with a termination provision. It's all recorded at the county clerk's office. You're welcome to verify it. Sheriff Martinez nodded and held up his tablet. I already did. Mr. Thornton is correct. The easement terminated upon the death of the grantor without automatic renewal. The subdivision's access road currently crosses his private property without legal authorization. Palmer's confident posture finally began to crack. Palmer's confident expression finally cracked. That's impossible. We have hundreds of residents who use that road every single day. I'm well aware of that, I replied, which is exactly why I've been trying to contact a legitimate Ridgeview Heights HOA board for the past 6 months to negotiate a new easement. Reasonable terms. Fair compensation. A solution that works for everyone. I paused. The problem is, I keep getting ignored or redirected to generic management companies that never return calls. So last month, I hired a licensed surveyor and had the property lines officially remarked. That access road crosses my land for approximately 900 feet. Every resident of Ridgeview Heights drives across my private property twice a day without permission. Kendrick was now scrolling frantically through his tablet. This isn't accurate. Our records show this valley as HOA property. Your records are fake, I said flatly, just like your HOA enforcement authority, your tactical jackets, and those official-looking name tags. Let me guess your actual scheme. You target landowners near subdivisions, claim their land falls under HOA control, threaten foreclosure, and pressure them into paying fake fines. Most people panic and pay. You just picked the wrong target. Sheriff Martinez straightened his posture. Gentlemen, I need to see legitimate identification, driver's licenses, vehicle registration, and verifiable documentation showing you represent the Ridgeview Heights HOA. Palmer tried to hold onto his false authority. We are official enforcement officers. We don't have to provide identification to property owners in violation. You absolutely do have to provide identification to law enforcement when requested. Martinez snapped. Right now, or I am detaining all three of you for further investigation. The men exchanged quick, uneasy glances. That hesitation told me everything. These weren't HOA representatives. They were criminals running a land grab scam, and they had accidentally targeted an attorney who owned the one piece of land their entire operation depended on. Martinez radioed for backup. Within 10 minutes, 2 additional patrol units arrived, along with a detective from the Property Crimes Division. The 3 men were separated and questioned individually. Their unmarked gray Silverado was searched, revealing fake HOA documents for 4 different subdivisions, portable payment processing equipment, and detailed records showing they collected more than $200,000 in fraudulent fees over the past 18 months. Palmer, whose real name turned out to be David Palmer, had a criminal history that included real estate fraud and forgery. Brennan, actually Michael Brennan, had prior arrests for extortion. Kendrick, whose real name was Scott Kendrick, was currently on probation for identity theft. They had been running the scam across 3 counties, targeting landowners near subdivisions and falsely claiming HOA authority. Most victims paid rather than fight. What they hadn't anticipated was targeting the one property owner whose land actually gave them leverage over an entire neighborhood. The detective, a methodical man named Rodriguez, carefully reviewed my documents and confirmed everything. The valley was mine. The easement had expired, and Ridgeview Heights had no legal access to the county road without crossing my land. This is fascinating, Rodriguez said. These guys picked the absolute worst property possible to run their scam on. You don't just own land they were targeting. You own land their entire subdivision depends on for access. I noticed, I said, which gives me significant leverage once the situation is resolved. The 3 men were arrested and charged with fraud, extortion, criminal impersonation, and forgery. Their scheme had targeted 43 property owners across the region, most of whom paid between $5,000 and $20,000 in fake assessments. The investigation revealed a sophisticated operation using convincing letterhead, bogus legal threats, and forged documents designed to intimidate people unfamiliar with property law. The case went to trial 9 months later. I testified as both a victim and an expert witness on property rights. The prosecution presented overwhelming evidence of systematic fraud. All 3 defendants were convicted. David Palmer was sentenced to 8 years in state prison. Michael Brennan received 7 years. Scott Kendrick was sentenced to 6. The judge ordered full restitution to all victims and praised law enforcement for dismantling what he called a brazen attack on property rights and homeowner security. The more interesting outcome came afterward. Once the criminal case concluded, I met with the legitimate Ridgeview Heights HOA board. I explained the easement situation in detail, and we negotiated a new agreement. They paid fair market value for a permanent access easement, funded road improvements along the section crossing my property, and installed clear signage indicating the road crossed private land. The HOA also implemented stricter verification procedures to prevent anyone from impersonating their authority again. I kept the valley exactly as my grandfather left it. I built a small cabin near the creek, maintained the open meadows, and preserved the natural beauty that had drawn him to this land 70 years ago. Every time I drive down and pass the Ridgeview Heights access road, I remember the look on those fake enforcers' faces when they realized they had tried to scam the one person who controlled their subdivision's only access to civilization. If someone ever shows up claiming your property is subject to HOA control, verify everything. Check your title at the county clerk's office. Review recorded covenants and restrictions. Real HOAs have legitimate documentation, and do not send men in tactical gear to threaten immediate foreclosure. They follow proper legal channels and provide real proof of authority. Document everything. Record conversations where legal, and contact law enforcement if anything feels wrong. These scammers rely on intimidation and confusion. The moment you demand proof and know your rights, their schemes collapse. Protect your property. Understand your ownership rights. Never let anyone bully you with fake authority. If you've dealt with property scammers or have advice on defending land rights, share your experience. And subscribe for more stories about standing up for what's rightfully yours.